Hey guys, and welcome to the weekly docket. Hey guys, good morning. We have got some actual case updates to look at today. So let's get into that. Pop this up a little larger. Let's start out with an interesting one, which is Alexee Trevizo. She's had some developments in her case and some things I think that are very worth thinking about for her case and also this type of case in general, where a mother, particularly a young mother, ends up killing a baby that they just had, which is terrible, of course, but we've seen it happen several times and sometimes in awful ways. Let's talk about maybe different ways to view that in the abstract and also in the court system. So let's go. Here's a picture from her recent motion hearing. You can see her sitting in the background as her attorney argues virtually on her behalf. She's out on pretrial release, and she was asking to be able to attend college classes in person and also not to have this no contact order with the boyfriend / father. And the motion results were that the judge will allow her to attend in-person college classes. And it removes the no contact provisions for the boyfriend father. So her attorney was successful in that regard. Now, of course, if she's out on pretrial release, why not be able to go to college classes in person? So I get that. So the stuff about the boyfriend / father is a little different, but nevertheless, I think if she's going to be out doing something productive like going to school, it's better than not doing that. Now, there are no rulings yet on the bigger items, the motions to suppress and exclude that her attorney is trying to get, and that he's saying there were Miranda violations, that she was in custody in the hospital at the time questions were being asked, and also that there was this type of physician privilege, which is apparently very strong in New Mexico, stronger than in some other states. And the state is saying, look, the police really didn't ask her questions that dealt with what she did. The doctors are doing that, trying to figure out what was going on and also for her health and safety. And so it was not custodial interrogation by the police. And then her attorney says, well, yeah, but they're not supposed to be able to do that. The judge has not ruled on that yet. In fact, the judge basically said, look, a lot of things happened. I'm not going to just make a sweeping ruling one way or the other. I have to look at how this thing unfolded and then make a ruling. So we'll see how that goes. You know, obviously that's your get out of jail free card that everybody wants to have in these cases. If you can have all evidence suppressed, that would be great, right? So here's a question here. Do we have any assurances she's not going to get pregnant again by the boyfriend father? And yeah, they gave assurances that that had been dealt with and that they were going to make sure that didn't happen. Now, I will say, you know, no contact order is kind of worth the paper they're printed on, so it's not like she couldn't get pregnant anyway. But the state did raise that as a concern. So I think they're not supposed to discuss the case or whatever is where it's at. So we will see. Good morning to Southern Florida and Ventura, California. How awesome is that? All right, let's move on with this because this is going to get a little spicy. And good morning to Texas. Somebody will be mad at me in just a moment. Let's talk about defense issues. You know, one thing I thought this was just, I happened to write this on the slide. It doesn't necessarily connect to what I'm about to get into, which is how would this kind of case be viewed? Because it's usually the mother doing the killing, right? How would this case be viewed if she and the boyfriend were together and she hands the baby to the boyfriend and then the father goes and puts the baby into the trash and kills the baby? Would there be less sympathy for a situation like that than she might get? About the same? I don't know. It's, you know, you kind of consider it to be like the ultimate betrayal, right? That the mother is killing a newborn child. So you've got a helpless baby and you can be extremely angry at that baby never having a chance that he never had a chance at life because his own mother killed him, if you believe that's what she did. On the other hand, sometimes when a newborn baby is killed, there's less drama around the case because there's not so much of a developed life. There's no pictures of the child playing basketball or saying things on a video and stuff like that. And the importance of that life can be overlooked too. So it can, I guess, go both ways. But anyway, what I want to get into were the potential defenses, right, that her side can or are raising. And one, of course, is the baby was not alive. You're not going to be able to murder the baby if the baby's not alive, right? But the state has pretty good evidence that the baby was alive, but still, if you're the defense, you want to keep that issue open, as well, of course, as, hey, if the baby did die, it was the hospital's fault, which, sorry, I don't buy that one, but whatever. If the baby was not alive, then where's the murder? Or that she reasonably thought the child was deceased. Now, they certainly bringing that up, and some of her statements would support that if you happen to believe her, that the child wasn't breathing, or whatever she called the little boy, things like that, that if she thought the child was deceased, then there was no intentional murder going on there. But more interesting, before we get to the really interesting one, which is she was drug senseless. The hospital gave her a bunch of drugs, and those caused her to act in a way that she wouldn't normally do. And she suffered from a mental condition related to pregnancy and the birthing process. And this could come into a diminished capacity defense, which some states have and some don't. We'll talk about that a little bit more. And I'm interested in this because you think, what's going on here? You know, why would a young mother murder a child? Yes, she didn't want to be pregnant at that point. She didn't want to have a child. She didn't want to face the options that she had to handle this birth. But killing somebody, especially somebody you just gave birth to, I mean, it flies against common sense, right? Like, that's awful. That's evil, right? That's terrible. It's worse than killing a stranger. It's just so bad. Why would somebody do it? And there's a case to be made, I think, that in some cases, there may be something going on mentally there that's different than an ordinary person would experience. She should be in prison. The baby won't get to go to school. Yeah, of course, she did get this unsecured bond or whatever for $100,000. So she's out. Now, she may very well be going to prison before this case is over. So we will see soon. Blessed day for Texas town. And that's good. That's cool. And rainy Scotland. Do you have to put rainy in front of it? Isn't it usually that way? I guess not all the time, though, right? So... but it always looks so cool. Has anybody ever taken a bad picture of Scotland? A picture in Scotland where Scotland doesn't look cool? I've never seen it. It always looks cool. Now, let's get back into the more serious part of this. So I'm going to show you this, and I'll explain how all this came up, because this is actually in the context of discussing this issue with another YouTube creator. But I pulled this and I put it in here. Let's look at it. That New Mexico does raise the ability for the defendant to rebut or put the burden more on the state in terms of showing specific intent for first-degree murder, the issue of intoxication or having a mental defect. And I'm not talking about insanity defense. I'm talking about, as you generally know, the state has the burden to prove every element of a crime beyond a reasonable doubt. And in first-degree murder in New Mexico, there's a state of mind element that they have to prove. You can see here, willful, deliberate, premeditated. Let's say that you say that, but you don't prove that, but you do prove that the person killed somebody, then it's very possible that the person would be convicted of the lesser included offense of second-degree murder. So a defendant has the option to not only contest whether they killed somebody or not, but to contest that they had the mindset. And in New Mexico, they allow voluntary intoxication to do that. Now, some states don't let you do that. They also let you show a mental disease or disorder to rebut intent, and not every state does that either. And this is the jury instruction. An issue you must consider in this case is whether the defendant it could be intoxicated from drugs. And like I say, they even let you do voluntary intoxication. Sometimes the use of prescription drugs, not the abuse, but the use, can be considered involuntary intoxication. At any rate, the drugs affected me, or this mental disorder that I was suffering under affected me. And then the jury has to determine whether or not the defendant was, whichever one of those was. And if so, what effect this had on the defendant's ability to form the deliberate intent to take away the life of another, or the subjective knowledge, the kind of what they call the depraved mind. The burden is on the state to prove beyond a reasonable doubt that the defendant was capable of forming this intent. If you have a reasonable doubt, then you must find the defendant not guilty of first-degree murder. So that's a pretty powerful set of potential defenses there that are not available everywhere, but they are in New Mexico. And let's get into that a little further. Intoxication in New Mexico is a defense to specific intent if it's to such a degree as to negate the necessary specific intent. Specific intent and general intent is just a bunch of lawyers sitting around talking about the level of intent necessary. So for first degree murder, the specific intent really is the extra element there that this was willful or premeditated or the depraved mind. That's called a specific intent. Beyond the general intent of just killing somebody, you did the thing to kill somebody. You have this higher burden of intent that they call specific intent. So New Mexico allows this intoxication instruction to be given if there's evidence to support it for specific intent, but they do not allow that instruction against the general intent second degree murder crime. So this could loom large in this case in terms of the defense trying to say the drugs impacted her mental state and getting that in front of the jury for the jury to consider. And it's a big deal. Here's how big a deal it is. First degree murder versus second degree murder there is potential life without parole or life sentence if it's first degree, or up to 15 years if it's second degree. That's a big deal, right? The other issue is the potential mental disorder that she might have been suffering. And this comes in a better discussion than I'm able to give it. With this video, you see a shot of it here, but I have the link to the video I put in the description to this video, and I think it is well worth watching. For one reason, I can't explain it to you as well because I'm not a birthing expert. That's not a shocker, right? But the issue here is potentially perinatal mood disorder, a type of depression that occurs during or after pregnancy. And can it rise to such an extreme level that a person becomes out of touch with reality? They're in denial of what's going on. Again, this is not a full excuse for a criminal act, but this can potentially negate the specific intent. So whether you agree with it or not, you should understand it, because if it becomes an issue in this case, it may be something that you see evidence on and a jury has to consider. And for example, True Crime Doula raises the point that if she was intending to kill her baby, think of some other cases where people have done that, like they have the baby at home and they bury it in the backyard, or they put the baby in a dumpster or something like this. This young woman went to the hospital where you're under surveillance all the time and there's physicians and stuff all around, with no plan to discard this baby if she did have the baby, right? So that's a poor plan, and it represents potentially either that she's sloppy and no sympathy for that, or she just wasn't facing reality. And could that go so far as to when the baby came out that she's in this level of shock and this mood disorder from being pregnant, that she was not having the specific intent to murder somebody rather than just trying to block out what was happening around her? Psychotic denial. I don't know the answer to that, but I think that is something that's interesting to consider. Let's talk about it a little bit more. Not saying I agree with it, but I'll tell you why I think it's interesting. So this was just to show that you can have this kind of evidence here, to show that there was not a specific intent. Again, not a defense to second degree murder in that state, but potentially a defense to first degree murder. So let's talk about it a little bit more. Consider the situation like surrounding battered spouse syndrome. For a long time, no, absolutely not. You're either in imminent fear of harm or death, or you're not. And then it developed that the law accepted the principle that, well, some people in certain situations, through what they experience, are seeing reality different than another person would, to the level that they may reasonably think that they are in imminent fear of death or bodily harm, even if they're not being attacked then, and this defense gets recognized. But people wonder, well, is it just going to be exploited all the time like Sarah Boone's trying to do? And it really hasn't been. Now, flip this to the other side. This slide I have up here is really about diminished capacity, that there's something going on in my mind that caused me to not have the ability at that time, or either not have the ability to form intent, or I didn't form the intent that first degree murder requires, a diminished capacity. A lot of states don't let you bring that defense up. They don't want it. There was a famous case where it's called the Twinkie defense, and this dude went on a rampage and killed one or two people. Pretty good evidence that it was all ultra deliberate. But they raised the diminished capacity defense that he had a diet of junk food, and that the junk food caused his brain chemicals to go out of balance, and he ended up getting convicted of manslaughter. So it's not like that defense by itself was caused skepticism about diminished capacity, but it didn't help it. So there is also the idea that if you allow it, that every case turns into I drank too much milk, I was sad that day, I didn't sleep enough, and things like that, where you really should be looking at whether did the person do it and did they exhibit acts that show intent or not, and not turn every trial into a clown circus. However, there are states that do allow diminished capacity, and I think if you take it seriously and it's limited to certain issues and things like that, then it certainly could be appropriate. As I say, I'm not an expert on this. I do find it confusing, obviously, that a young person would kill a baby, because on one hand, you can see why they would do it. They don't want to deal with the child. They don't want to deal with the social fallout. They don't want their life derailed. A lot of things like that, right? But still, you're talking about killing somebody. It's just awful. So I certainly think the majority of those cases support the charges that are levied against people. And in this case, I've said before, which I still do, that first-degree murder is an appropriate charge in this case. The question is whether the defense should be allowed to explore the idea that maybe she didn't have the mental intent for first-degree murder at that point and explore it. The law definitely in New Mexico, in my opinion, says yes. And here's what's interesting about this is when we first discussed this, True Crime Doula and I went back and looked, and I, for whatever reason, was thinking about another case and looked up the law in Arizona. They don't allow this type of intoxication as a defense or diminished capacity defense at all. And then she's like, well, that's a cool story, but this case is actually in New Mexico. And then I remembered it was, but it just goes to show you go over the border in New Mexico and you can bring these defenses up as a defendant in a case like this, whereas you would not be able to do it in Arizona. But the question is, is this fair? Is whatever. Now, if she does raise it, of course, the state is going to be able to say, that's a smokescreen here, and here's why. And they may have evidence, of course, that she told other people that she was pregnant, that she was naming the baby and things like that. And that goes against the idea that that she didn't know she was pregnant, that she was blocking that out. I think on the defense side, it's pretty clear that she didn't have a healthy relationship in terms of talking to her mother about that situation. She denied it to her mother and stuff like that. That's for sure. And what about her behavior after this is over? Has she gone checked herself into a mental place for a while and showed a lot of remorse and like, I can't believe that I did that. Oh my God, what did I do? I'm so sorry about it. If she did that, her team has not gotten that out there, because all you really hear about is her wanting to dodge talking to the police and going to school and taking pictures at the prom. And nobody really seems to be worried about this baby. Not only her, and she was the one pregnant, if she were suffering from this disorder, but anybody in that family care about this child? Or they just all don't care? That's what it looks like to me. So I don't like her. I don't like what she did, because I am, hopefully, in a not in a controversial position, anti-baby killing. And then secondly, I'm anti not caring about baby killing, which is the behavior they appear to have exhibited. However, you have to look at the law of each state if you're going to look at cases and understand what can be issues in a case, and then look at whether you think you agree with that or not. And I think that's very appropriate here. And I think if there is a disorder like this that is the reason why some of these crimes are committed, then it's good to try and find ways to deal with it, either to prevent it on the front end, like the Safe Place Act that they had in New Mexico, where this child could have been turned over there, could reduce some of the pressure of having a child. Is there some better counseling that could be taken? Not that she would have done it in this case, because they were trying to run away from the situation, not embrace it. You don't want this to happen to anybody. If there is a situation where a woman kills a child that she just had from a mood disorder, that could have a long-term, obviously, negative psychological impact on her, as well as the death of the child, and any ability we have to stop that from happening, we should. But if we're going to consider mental state and specific intent and things like that in other cases, why wouldn't you also allow it to at least be considered in this case? Again, right now, it seems to me the evidence rebuts this to some degree for her, puts it more on the side of she was... maybe at that time she went to the hospital, which True Crime Doula makes a good point. She didn't have a plan to discard the baby. Maybe she didn't know she was ready to deliver. I don't know the answers to all that. It looks like she killed the child on purpose to me. But I'm not a birthing expert. I'm not a woman, and I haven't had a child, and I don't know how those things can impact you. So I would have some humility on that and say I'm open-minded to hear more about it, even if it doesn't apply in this case. If it's a real thing, which it could be, for all I know, I think justice requires having an open mind to things like that. Now, let's see what people are saying about this. ridiculous, outrageous comments I'm making. I'm criticizing myself. Her actions of wrapping the baby and hiding him goes to the defense against being affected by the drugs given her shock, in my opinion. I think that's an excellent point on the drugs. I really do, because it's a purposeful effort at concealment. Now, it could be consistent with this idea that she's in shock and denial from the mental disorder, that she didn't want to allow herself to realize the reality of the pregnancy, that it was upon her if the child came out, and if she didn't think the child were alive, to hide it might be her way of causing this all just to be over in her mind if she's in some kind of disassociated state. Again, I'm no expert on this, so I'm not even saying what I'm saying makes sense from a psychological standpoint. I'm just giving it to you as I understand this kind of thought process. But I think your point here, that the hiding of the baby definitely goes against the drugs being something that could cause the requisite intent not to be formed. Now, having said that, her side could say this. If she's guilty of anything, it's second-degree murder, okay? And the hiding of that could be evidence of second-degree murder. She killed this baby, but the hiding of it doesn't show that she thought she was killing a child at the time the child was born, because she thought the child was dead and she was in this dissociative state. What she did want to do was hide it all so that she could move past it. I'm leaning in your way, but you know, you're probably going to hear arguments about this stuff, but I'm leaning with you on that one. Here's a comment. I appreciate hearing possible defenses. I believe her mother shows that she's been shielded from accountability her entire life, so I have a lot of skepticism about any defenses. Yeah, all right, I think that's fair. And I think on the side, you know, for her, they're going to say, well, the mother is part of the reason, you know, could have contributed to how her mind ended up framing this incident, the fear that she had of, you know, this, that, or the other. I don't know if that's fair to the mother or not. I certainly was not impressed with the mother's actions, particularly when she was being arrested. I was like, for what, bro? For what? I mean, you're going to get probably arrested for something in a situation like that. So challenging law enforcement like she did, it wasn't making me sympathetic to her. And so I believe this comment is from the True Crime Doula, who, again, I have linked her video there, and I do see, as I say, I think her video is very thoughtful. It's definitely something to consider. Is it going to be borne out by the evidence? Is it a thing the law should recognize in every state? Those are good questions. But I also saw the comments to her video where people are like, what the hell are you doing? And, you know, why would you tell the defense this and stuff? As I say, I'm anti-crime. I don't like murderers. I don't like killing babies. I don't like people to get off on technicalities and things like that. But I'm also very pro due process. And if the state recognizes this as a potential defense, then it is right to explore it. It's also right to assess the evidence if you do and say, no, that doesn't apply here. It might apply to somebody else, but it doesn't apply to you. It's not like just because you get to raise a defense that, you know, you're going to see this as we move through the stream, you get this get out of jail free card. For one thing, as I said, it is not a defense to second-degree murder in that state. So it is just a defense to the specific intent of first-degree murder. And here is a very succinct comment. Her lawyer is full of crap. And that can be true, too. Now, I like to be analytical about things, but I'm as human as anybody else. I know that might be hard to stomach and believe since I'm a lawyer, but I think it's true at least, right? So I do get aggravated at what I see as their conduct in this case, not treating it seriously after it happened. That has an effect on me. The other thing that has an effect on me is the filing of the civil lawsuit against the hospital for money, to get money. This family wants to be paid for this dead baby boy. And if she had a defense of, well, I suffered a tragic mood disorder, you know, that caused me to act in this way without specific intent, it's hard for me to think of her neutrally in a context like that, knowing that they're hoping to get a lot of money from a solvent entity, the hospital. That's what the civil suit's for. It's to get money. It's not a defense lawsuit and the criminal thing or something like that. You know, could she use this theory on the criminal side? Yeah. You don't have to file a civil lawsuit against the doctor, the nurses, and the hospital. You don't have to do that. The reason you file civil lawsuits, generally speaking, is to get that money. So I think that's disgusting by her family in this case. It's absolutely disgusting. It is hard for me to view them with any sympathy. But I still say, or agree, that I think this issue is a larger one to look at, whether it's a good defense or a successful defense in Alexee's case. Is there an explanation beyond evil that when sometimes a mother brings harm to her newborn child? Is there something going on psychologically there that we ought to try and work on to help these women either prevent it or mitigate it? And should the law recognize that? Because it does in other contexts, as we've discussed. You know, again, whether it applies to her case or not, I don't know the answer to that. I think there's a lot of evidence that's going to come out about this in terms of what she said before and after. It could help or hurt. But when True Crime Doula brought this up, I thought, well, you know, that's an interesting thing. And that's what I said to her. And a very interesting thought process. And sadly, I looked at the Arizona law and said, well, you can't use it anyway. But when I came back to New Mexico and saw that you can, I would be shocked if this doesn't come up. That's my opinion on this. And then I think it is worth discussing. The horror of somebody murdering a baby is absolutely terrible. And I think lots of bad things about people who do that. And it can be hard to keep an open mind to, well, why would somebody do that? Could it be a mental fault? And I agree, she's not the poster person for this, for her behavior, lying all the time and celebratory pictures at the prom right after the baby has died and things like that. Those look pretty bad. This civil lawsuit, it all looks bad to me. And she says, I don't know. Maybe I put the wrong channel before where I said I thought this was this one. I'm dealing with some bad glasses. But this is, thanks for considering my perspective. Well, yeah, I think it's a very interesting perspective. And as I say, I encourage people to watch the video because, you know, when you go down some of these rabbit holes like the battered partner syndrome, there's a lot of thinking to do in that. Like, could it be abused? Is it real? Is it ever real? Is it just an excuse for something you did on purpose you shouldn't have done? And this is kind of like this. You know, I'm pretty far away from understanding what it's like to be pregnant, even if sometimes I may look pregnant. I'm not. And so in that case, I don't know all the changes that can occur in your mind as a result of that, before or after. I don't know. So I think, you know, I wouldn't go around saying, well, if people kill babies, let's just assume they're not responsible for it. And you're not saying that either. But I think what is being said is that there can potentially be a situation where the person's doing something that is kind of out of their right mind. And does that make a difference between first degree murder, like your Ted Bundy, or potentially criminal conduct, but that the law ought to treat it in some slightly or significantly different way? It's interesting. So she should be charged with murder. And if you're talking about Alexee, then she has been first degree murder. So she can't face really a more serious charge. And I think that's appropriate here. I'm just saying that I think it's appropriate to consider the defenses that the law allows there, not only because if you're going to watch the case, why be caught off guard with an issue that you see come up in this state that might not, that the defense couldn't potentially be able to put up in another state. Like look at Taylor Schabusiness. She couldn't do diminished capacity. She couldn't talk about the lack of capability to form intent in the guilt phase of her trial. She had to try to use the insanity defense, which is different than what we're talking about here. So every state is different, as I always say, and it always depends. But I think the charge is appropriate here, and I think the consideration of the defenses is appropriate, and what the ultimate outcome should be. Is she a budding Ted Bundy, or was this an anomaly that mentally she didn't have control over? Well, you've seen how the evidence stacks up so far, so you can have an opinion on that, and I probably agree with it. They prove their real selves, not hospital room, and again at their house. I completely hear you on this. She is not a sympathetic individual to me, and nor is the family, with nobody, from what I saw, maybe they'll have something to show this later. Nobody showing any concern for the infant, for the newborn boy, even asking if it was a boy or a girl or whatever. It just didn't seem to register as important at the time that it happened or after it, right? Now, again, we only see what we see on social media and stuff, but from what we see, I think it looks pretty. Maybe her mom is doing a lawsuit because she wants money for a good lawyer. Yeah, I didn't check whether this attorney she's got is appointed or not, but however, I mean, he seems to have been very active on her case so far, her criminal defense attorney, I'm saying. And if you're trying to do this lawsuit because you want money for a good lawyer, it can take quite a while to get that money. But I mean, you file the civil lawsuit because you want to get paid. That's what the civil lawsuits are typically for. And hospitals and doctors are often targets, and sometimes rightfully so, right? It's just in this case, boy, do I I don't like this one. I think it looks awful, and I think it is awful that after this child was put into the trash and denied a chance at life, and no one showing any concern for him, and then go to the prom and do this and do that, and then now here comes this lawsuit about, oh my God, we're never going to be able to spend time with this baby boy, and he's never going to be able to grow up, and you know, justice requires that this hospital pay this super large sum of money to, you know, on behalf of this child, and then we'll go to the family. No, I don't. The civil lawsuit, I have a absolutely certain opinion of there, that's for sure. Sorry, but the lawyer reminded me of Dr. Lewis. Yeah. But I think he's achieved some results, right? He's gotten her out, pretrial release. He's gotten her able to go to class. He's raising some issues and stuff. But you know, if they want a different lawyer, they can get the money together to do it. That's all on their side of it. I'm glad I'm not representing her, and I certainly wouldn't be doing the civil case. All right, so that's a lot to think about there, I think. I'm not disagreeing with anybody who says, hey, she did it, she's responsible for it, because that is, you know, pretty much where I'm at. But I'm saying that I don't know that I would apply it in her case, but I would want to think more on this issue of, as you see these kind of cases come out of a newborn infant, and sometimes a few years after that, a child or whatever being murdered by their mother, like, why does that happen? It can just be sick and evil and all that, but you know, maybe sometimes there's more to it than that. I'm not for excusing it. I'm not a crime softy. Trust me on that. Let's move on to another one and talk about abusive defenses. Sarah Boone. And if you watch the streams where we went deep dives on the docket, you know that she's had tons of experts in her case, and that she's had 6 lawyers. This is the 6th, but only one of the lawyers who's left the case did it because of their interactions with Sarah and their conclusion that they have differences that cannot be reconciled and need to get out of the case. I'm going to come back to this comment here for a second here. All right. Amazing that a mother could be clueless to her daughter's obvious pregnancy. She makes it seem like because she was still buying her pads, she had every reason to believe Alexee wasn't pregnant. I know what my wife's opinion of that is, that no, she knew she was pregnant, or should have known it at least. Yeah, who knows, right? Alexee had no signs of mental illness at school. To the degree that we know, I agree with you. And again, just because the defense is out there doesn't mean the facts apply to it, right? So first of all, you have to think, should this even be able to be a defense, whether it works for her or not? And some people say no. Some states say no. And then if it is a potential defense, like it is in New Mexico, does it apply to the facts of the case? And that's where I think Alexee can run into some trouble. But I think the broader scope of, is there a potential mental defect that could affect, you know, if there are millions of women who have babies, and is there 1 out of a million that it creates such an imbalance that they do something that they shouldn't do, wouldn't do, or whatever? That's not inconceivable to me. Is she the poster person for that? I'd have a tougher time with that one, but I think it's very interesting to think about. That's my opinion, and I respect the different ones. All right, so this dude here, as Big Von is chiming in, this was his 2nd time he filed a leave. Talk about Sarah's 6th attorney. So he filed a motion to withdraw at the end of last year, and it went before the judge, and the judge notes that Sarah did not end up demanding he leave the case, and he stayed on it. So the judge sometimes will, when you try to get out of a case, try and smooth it over to see, well, what happened here? Can I patch that up and keep you in the case? Because, you know, it's disruptive to change lawyers and stuff like that. And that was my experience. I tried to get out of a case, and remember, you know, I saw Court TV had a headline, he's withdrawn out of the case. But although I think in the particulars, they may have had some of the facts right. You can't withdraw out of the case when you've appeared in it until the judge lets you out of it. So that's what he's asking for. I think he even says permitting the court-appointed counsel to withdraw is what he's asking for. So the judge has to grant this. And he has noticed this hearing for September 8th. Saw that this morning. Now, he says in this a little spicier than his first motion to withdraw. You've seen where he's saying that she won't be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone. And paragraph 5, the best possible outcome is to have the defendant represent herself as an attorney, or as no attorney can satisfy her, is what this guy is saying. As I've said before, you try not to have any kind of issues about you and your client in the motion to withdraw if you can, because there's professional obligations, and usually the court's pretty respectful of that you don't need to have it in black and white what's really going on between you and your client. But he's putting a little extra spice in here because he's really tired of all these letters being written about him and her demands on him. And, you know, whether she has some points or not, it's obvious that the distaste is mutual at this point. And so the judge is going to have to decide on September 8th, do I let this guy out or not? And if he lets this guy out, then what happens? Does he appoint another lawyer, or does she go pro se? Now, some people are like, oh my God, I hope she goes pro se. That would be insane. I agree. In terms of watching it, if we do get to watch it, that her going on in terms of a victim mentality about herself, Sarah Boone I'm talking about, would be some real pro se clown type activity. Darrell Brooks, graduate of I'm the Only Thing That Matters law school, for sure. And I don't see her wanting to do it, though. I see her being more receptive to the idea of, I'd like to criticize the other people, I don't want to do it myself. So then she would end up with a 7th attorney. But either one of those that occur, the case was going to get continued from October anyway. So it was going to go into next year anyway. They'd already discussed that with this attorney. So it's not like it's going to hold the trial date. But I would bet she doesn't want to go pro se, because that's a road to disaster. And she may actually even know that. But what she is wanting for her case, I don't know that she's going to achieve, which is this battered partner spouse syndrome defense, which would relieve her of criminal responsibility. And she's had experts all the way back on this thing on that. And now they want a new expert. Like, what happened to the other experts? Why can't they testify? Did they not say what you wanted them to say? All of those are questions in my mind. I don't think the facts support to any degree a battered partner syndrome. It's a ridiculous misuse of the whole concept in her case, but you can understand why she wants to grab onto it, because she doesn't want to be responsible for what she did. I'd love to see her go pro se. Hey, you're not alone in that. A lot of people do want to see that, because otherwise when she's in court, she's going to be sitting there while her lawyer talks. So we'll have to see on that. I just don't see it. You know, is she going to go, if you want something done right, you have to do it yourself and take over the case? She has plenty of time to do it, but I just think she's not the personality to do it. I could be proven wrong, though. Let's go out west to Idaho. What you're not seeing here is under this logo I've got up here, Southern Laws. I'm now putting the states on there, so I don't forget which, not that I would forget Kohberger, but don't forget which states these cases are in and look up the wrong law again, because that would be pretty embarrassing. Yeah, Sarah wants to go home because she's had enough punishment. That is how she feels about it. She has to live with this for the rest of her life. No one can do anything worse to her. Just let her out. That's all she's asking for. And the meanies at court won't let her do it. And answer this question again, because it does come up. Why won't she take a plea? And again, the answer to that is we don't know that she's been offered a plea. We don't know that she's asked for a plea. And the more time she spends in jail, the more time she has in bank, though, so that if a plea is extended or requested and the state considers it, then she has something there to offset a potential sentence. So eventually, hypothetically, if the case drags out far enough, a plea for, say, manslaughter or something like that could look attractive versus rolling the dice and maybe staying in jail or prison. So, you know, the calculus can tilt there, even if she thinks she's been tread upon. Nevertheless, it can still be a good idea to take a plea if the evidence puts you at a great risk, which it does in her case. Pro se, no way this will happen. Yeah, I think unlikely as well. I just don't think she will do it. Kohberger's had a lot going on this week. It's, you know, kind of built up to this event where he waived the speedy trial. And that's not unusual. I mean, in most cases, you're going to have a speedy trial waiver, especially if they're complicated, because the defense wants to be able to marshal resources to fight against the state's case. Now, hypothetically, if the state has a super weak case and they haven't developed it well yet, you'd want to get on into trial so that you could beat it. But let's say potentially the state has a stronger case than social media wants to sometimes recognize, then maybe you need to spend more time preparing for it, because if you get convicted, you're going to go away for a long time. So he waives his speedy trial, and we'll talk a little bit about the dynamic of that. So His attorneys had asked for a stay. You'll see that in another slide, a partial stay. And the state said, no. They either want to waive the speedy trial rights or they don't. We're either going to trial in 6 months or we're not. They can make whatever motions they want to make. But if he wants to stop this case, then he needs to waive a speedy trial. And eventually the judge agreed with that, as we'll look at in a little more detail. You have to let that lawyer go. Likely, I would say this time he's likely out of there. I think he's likely out of there. You're at the judge the second time wanting to get out of the case. So, and if you're Sarah, knowing that you don't like this guy and you put him on the record about how terrible he is, and he doesn't like you, is that who you want going to court for you? Let's look at this thing here with this get out of jail free card, because that seems to be what I think some people think the results of these motions would be, and it's not. And we'll talk a little bit about maybe the bigger picture for defense strategy in this case. When the action may be dismissed, and in this case, speedy trial, it potentially could be dismissed if it's not brought to trial within 6 months from various triggers that they have. But look at the top. It says, unless good cause to the contrary is shown. So even if Kohberger had not waived his speedy trial rights, it's not like it's absolutely for sure that the state wouldn't have asked for a delay themselves and the court granted it. That does happen. They just have to show good cause. And during the virus situation, good cause was assumed. So the cases don't always have to go that fast. But here, from what I saw, the state had not asked for a delay. They were ready to go to trial, or at least not trying to stop it. And so finally, his side blinked. But look at this at the bottom, because this is going to be important for several of these things. Effective dismissal as bar. This is not a bar if the offense is a felony. So for a lot of these things that are pre-trial that are at issue in this case, if the defense were to win right now, the solution would be just to re-indict. That's not very exciting, is it? So we'll talk about what are they really trying to get out of this. The court also said after this argument, goodbye vague alibi. So let's condense the nonsense about that. My alibi is I was driving around at places where I can't tell you where I was or anything, but maybe I'll have somebody who can tell you later. That's not really an alibi, or not a good one. If the defendant intends to rely on the defensive alibi, a notice of alibi with a specific place or places defendant was at the time of the alleged offense, and the name and addresses of the witnesses he intends to rely on to establish that alibi is due by September 8th, 2023. So you may see another filing by the defense on the alibi if they want to attempt to preserve that. Now, you don't have to have an alibi. It's the state's job to prove that you were there committing the crime. So you can always challenge that. But if you want to present evidence, I was at place B, and here's a witness who says I was at place B, their rules require that you designate that before trial, so that it's not some kind of surprise thing that comes up. And that has not happened in this case. He basically said, I go out and drive alone. I don't know where I was then. Okay. Now, he can still do that himself. If he wants to testify to that, he can. But if he wants to call other witnesses, then you can see the court's ruling right here. Surprise? There's not going to be a surprise. The court said the parties will provide each other with a list of their witnesses, lay an expert. And so you're going to get the witnesses. You're also going to get exhibits. And if there's not an objection, the judge would like those to be admitted prior to trial. That's good for efficiency. Let me go back to this thing about September 8th. Now that the speedy trial rights are waived, I think this date itself may be vacated. I'm not sure about that. I think they've pretty much vacated all this stuff. And remember, what his team had asked for was, before they waive speedy trial rights, would you just give us this little delay so that we can challenge the indictment in the grand jury, but not actually stop this whole thing with a waiver of speedy trial rights? And the court said, nah, based on what you're telling me about what you're having to say about the grand jury and the indictment, I'm not going to do that for you. And so the court said, I'm not going to stay it. And we'll have a hearing on your indictment on September 1st. Any additional motions regarding dismissal indictment by August 23rd. And they have filed that motion. We'll take a look at the page of it. I'm not sure these dates held after the waiver, but nevertheless, I did hear his attorney, Ann Taylor, saying that she wants to litigate the issue on the indictment first before they move on to other things in the case. And that seems reasonable to me. If there's a flaw in the indictment that would cause the court to dismiss it, why would you want to do all this other work downstream from that before you resolve that? Yeah, I think still talking about Sarah there. I think we're going to see lucky number 7 here pretty soon. So here's the motion to dismiss the indictment. Biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Wow, let's take a look at that. You can't take a look at it because it's all under seal. Now, they're still going with that argument that the grand jury was misled by saying that they had to meet probable cause instead of beyond a reasonable doubt. So not all arguments that glitter are gold, and we really don't know the details of these arguments because it's all under seal. I mean, I'm skeptical of them because it's usually not that tight of a requirement to get an indictment on probable cause, and there are some things that can allow certain flaws to occur in it as long as they're, it's not material to it and stuff like that. Because you're talking about an indictment, not a conviction. It's probable cause, regardless of how they want to change the law here. Having said that, I can't say that nothing she has here has any merit because you can't read it and see it. However, if she does want the indictment dismissed, I think this is she's doing the right thing by getting this in front of the court now, so that they don't do all this other work before the judge decides whether the indictment stands or not. Now, what's this fight really over? If the judge says, there's a flaw in this indictment, I'm dismissing it. It's not the get out of jail free card, basically speaking. They'll just issue a new indictment. So how exciting is that? I think there's a thought that, this one simple trick will allow you to get off of a quadruple murder charge and never have to face trial. And the law's not so simple. And why should it be? We shouldn't convict people on technicalities or let quadruple murderers, if that's who they are, walk free because, some slight problem or whatever. The remedy is to fix it. So if the motion is denied, though, if the judge says, this indictment's good, and you go forward with the case and you get a conviction, then it preserves the issue for appeal. And that is the smart angle for the defense here. Because if he goes all the way through and gets convicted and some flaw in the indictment that is material enough that it should have been dismissed exists, then in theory they could get the result kicked out and probably a new trial. But, they would have this downstream as an appeal issue. So I think that's the issue there that they're trying to get to, and you'll see that on some of the things that they're doing. The grand jury, the indictment and stuff is, if he gets convicted and the judge doesn't make the right ruling here, that could be a saving grace for him. And that to me is a little bit like this family tree genealogy that they're fighting over. What's really going on here? What's really at issue here? Well, one argument the defense has for why we need to see it is to get an understanding of the developments of the leads on Kohberger, how this all came about. And I get that and I respect it. And if I were going to allow them to see more of it than what they've already got, it'd probably be on that ground. But what do they really want? I mean, they want to be able to argue that that the use of this family tree evidence, the way it was done, that everything downstream of it should be thrown out. I've seen some people post that on Twitter and like it's, like, oh my God, if they find this one flaw, in the term of service or something, the quadruple murder case will be dismissed and you can use your get out of jail free card. Yeah. Now here's an interesting thing in terms of excluding this family tree evidence. The state has already declared its intent to not use that evidence, the family tree part of it. Yeah. So you could just wrap this motion right up and say, well, the state won't use it. Therefore, you don't have to worry about contesting it. So we don't have any issues there. So that's not what they're fighting over, right? Could any of this come into evidence? So the defense wants to see it. What would they do with it? Would they bring it into evidence in some way to rebut the primary DNA evidence against him? That seems unlikely because this family tree evidence supported that it was somebody in his family that did it. If I'm the defense, I don't want that up in there. So I don't think they want to bring it in either. But the holy grail is this idea that, it's fruit of the poisonous tree, that if the investigation were tainted even slightly with this family tree evidence, the whole case should be thrown out, suppress everything. But the existing law does not support this for lots of reasons on the way the exclusionary rule works. But let's take it all the way back up to the top, which is, can they win this argument in the first place? And the way the law exists right now, they are behind the 8 ball. It's really, I'm sure, a case of first impression. It would be at the appellate level in Idaho because it is in a lot of states. But here's basically how the law works. You've got to have an expectation of privacy in this evidence that's searched if you want to complain about the violation of a search. And Kohberger's DNA at the scene on the knife sheath, however it got there, let's say hypothetically he dropped the sheath there, as the state says. So his DNA is considered abandoned there. So they're not going to be able to keep a potential murder suspect's DNA found at the scene from being used by law enforcement. So that side of it is a non-starter. But the other side of it is his family's DNA in these databases. So the general rule is you have to have, in order to have standing to complain about it, you have to have this right of privacy or an expectation of privacy in what is being searched. And he would not, because this is family and relative stuff. In fact, this exact case came up in Washington at the Court of Appeals, just recently released decision, where that's what they said. They said that, you can't argue about whether that search was violating somebody's expectation of privacy or not, because you can only argue about whether it violated your expectation of privacy, and you don't have one in other relatives putting it up in these databases. The court there also said the whole point of putting the DNA up in the databases is so people can see family relationships. So it's put out there for that purpose. Now, I know that there's the idea that, if the term of service, this, that, or the other forbids it or whatever. Well, we don't know that happened here. We have no idea whether there was a term of service that the FBI didn't follow or something like that. And I'm sure the defense would like to find it out. But even if they do, what's the remedy here? And as the state points out, we're not trying to use his family DNA against him at court. We will not use that evidence. What we want to use is the sheath evidence directly compared to Kohberger himself. That's what we want to use, and potentially compared to his father's DNA that we took out of the trash can. Now, there are lots of ways to contest his DNA on a sheath because it's trace DNA, and you can argue about that. You can argue about how it got there and all the things that you can do against trace DNA. That's different than using this IgG to say that any flaw in obtaining that taints everything and every other aspect of the case. I think the law is very against them on this. But, because this is relatively new, there's only so many appellate decisions on it. But so far, they seem to be falling in favor of what the state's argument here is, that if it's in a public database and law enforcement looks at it, the criminal over here doesn't have an expectation of privacy in what other people have put in databases over here. And that is the general law. So I hope I haven't made that more confusing than I should. I was trying to come up with some better examples for this, but if I'm the murderer and they search my car and they find a body in it, but they had no probable cause to search the car, I might be able to get that body excluded. But if I stuff the body in somebody else's car and then the police eventually open that car up with no probable cause and look in it and they find this body, there's a good chance that body's still coming in, because I can't argue that their improper search of that other person's car affected me because I had no expectation of privacy in that car. You see what I'm saying? So that's what they're saying here, is that his standing would be on the DNA on the sheath, okay? And his standing is not on other people's DNA that's in this database. So that's a huge legal issue they have with their argument. In addition, then also, even if there were standing, whether there's an expectation of privacy in these databases, and that was 0 for 2 in the Washington case, which isn't certainly binding on Idaho, but I think that's what they want with this. They want the court to look at it now maybe and say, we'll throw everything out. But more particularly, again, kind of like this issue with the indictment, that if the court rules now, hey, I'm going to allow this to go forward, if he gets convicted and they need to appeal, they have a fairly novel issue to bring up on appeal, which is, the justice system the appellate court should stop this and stop these searches of these databases and things like this. I don't think that would win, but I think it's responsible for his attorneys to raise that issue because it's first impression. So I think that's really what this fight is about. And a lot of it about preserving his ability to appeal downstream if he's convicted. So some of it seems to have the effect of delaying the trial, and people are like, why is he putting families through this? This is terrible, the justice system to do it stuff. But in complicated cases, they generally take quite a while to do it. There are a lot of complicated things to litigate. And these preliminary motions about the indictment and this family DNA stuff, that's just the opening salvo. As they get closer to when they really would be doing trial, you're going to see motions in limine from both sides and arguments about the scope of things and which exhibits can be put in and which ones should be excluded, and the judge trying to decide all that before the trial starts if there's serious arguments over evidence. so that the trial can be smooth. So that's why you have these, motions in limine, which are pretrial motions over whether something's going to be allowed in evidence or not. And here's where I had seen where the state said that the state did not rely on the IGG information to establish probable cause for defendant's arrest. And that's interesting, right? They're saying they had other information that established probable cause for his arrest. They did not present the IGG information to the grand jury. So the family DNA stuff, the state says that wasn't even used by the jury to return probable cause for an indictment in this case. Interesting. No plans to present the IGG information for which a protective order is sought as evidence at trial. And they will rely instead on the direct comparison, as I said before. So, and the state saying this is all a tempest in a teapot because it's not what was used to get the indictment against him, and it's not going to be used at trial. And it's important, but the defense is still going to bring this issue up because it's kind of novel. The defense will be an endless succession of baseless arguments for appeal purposes. Yeah. And, because you want to be fair to everybody, if there's 15 baseless arguments, but one of them has a basis for it, you still got to be open-minded to that. But their argument here to me is not strong. And as that's legally speaking. Social media speaking, what's interesting to me is people who declare that he's innocent, which, if you think that, that's fine. The family DNA being used to draw the link to him to some degree as a lead, finding some technicality in the 8th page of a term of service that you want to try and argue that this evidence should be discarded if it's true, is not supporting the idea that he's innocent. Like, why would you want somebody to get off on a technicality? Why wouldn't you say, let's look at all the evidence and here's why I think, Kohberger is innocent, or that there's not enough evidence to say he's guilty? Because the family DNA supporting him being the person who left the DNA on the sheath is here compared to the fact that they did an actual comparison to his DNA that showed he was the person who left it on the sheath. So what does that even got to do with anything? If there was a flaw down here, it has nothing to do with whether he put the sheath there with his DNA on it. The real argument for that, I think, is arguing about the trace DNA. And we've gone over that in some videos, some of the good arguments that there are about how DNA can be transferred and whether they apply in this case or not. That's the real argument. Not finding anything from the victims in his car, that's a point for the defense. I mean, I don't think that shows that he's innocent, but I do think it's a point for the defense, and you have to look at all of that. But trying to find a get out of jail free card, that term of service or, the indictment didn't have a certain number on it or something like that. That to me is all crap nonsense. A defense shouldn't waive anything if they make a minor technical error, and neither should the state. It shouldn't be some kind of, it's not a game of basketball. This is real life. There's a person who is on trial for his life, and there are 4 people who were brutally murdered, and all of those people deserve better respect than to have their cases decided on any kind of super technicality. Eventually, you'd want the truth to come out, and you'd want to know, did this guy do it or not? And is there probable cause to support bringing him to trial? That part is obvious. Whether there's substantial enough evidence to support him being found guilty, you have to see the trial for that. Yeah, the court will determine his guilt or innocence, not TikTok. People got to chill. But, people like to argue, of course, and that I have no issue with. But it is often wrong. Oh, my God, they said that the state engaged in misconduct in this case. This must be terrible. It's arguments by the defense, people, and some of them may be good. Some of them may be bad, but this is also, not only is it not going to be decided on TikTok, but it's not going to be decided by headlines of people who do not bother to actually really read the documents that are being filed. And if they did, they wouldn't bother to understand what the arguments are in them, because some of them are quite complicated. Now, the judge in this case, I think, has been very level-headed, and he's plenty smart, and he will understand all this and do the best he can to make the most accurate court rulings. That's for sure. So it is terrible that the victims' families have to wait for justice, but that's a consequence of a complicated case. It's not terrible that he has to waive his speedy trial rights, as some people act like this is some kind of dirty trick by the state to force him to waive his speedy trial rights. Nobody forced him to waive his speedy trial rights. If he wants to move on, bro, move on. Get to trial. If you're not guilty, you're not guilty. The fact that you can't stop the case to litigate the indictment doesn't matter, because they could just issue a new indictment. So as the case moves on, just file your brief about how all the law should be changed and the grand jury was terrible and stuff. And if you're right, you'll get the conviction reversed. So get to trial, bro. If you're innocent, get up on in there. Nobody forced him to do that. He did it because he thinks that's the best to prepare his case, and he's probably right, and he does deserve the time to be able to do that. So that's my opinion on this joker. Obviously, I think they have the right guy. I really believe that based on the evidence that I've seen and just other things about this person. So, but you know, I haven't sat in the courtroom and listened to all the evidence from the state or from his side and their arguments. So that's what the trial's for, right? My opinion is not really much better than a TikTok, except I do actually try and read these things and apply the law to them. But as you decide whether the facts support something or not, everybody's opinion becomes basically equal at that point, I think, as long as you're being reasonable and not stupid. And there's plenty of stupidity on this planet. So what are the unknowns in this case? The state probably has more evidence that you don't know about. I mean, I saw somebody rebut that by, oh, they leak every single thing, so they don't have any more evidence. And that's crap. What evidence has the defense developed that is unknown at this point? Well, another important point. We don't know. We don't know whether they found something important or not. It is the case that sometimes people have been framed or evidence lied about, or you find this super material thing or whatever. How would we know if they haven't released it? And a lot of the stuff in this case is under seal. And even if it's been exchanged between the prosecution and the defense, it's not out there in the public. And of course, a lot of motion practice, how the judge rules on the admissibility of a lot of evidence, even if it's, you know, if we know it out here, is the jury going to be able to hear it or not? That's going to matter for this case a lot too. So that, oh boy, this lasted a long time. I knew it was kind of a big one, and I hope you have found it interesting, because I did. A lot of these issues are really interesting to me on an intellectual level, in addition to the cases they apply to. The stuff about Alexee and Kohberger in particular. Sarah Boone is just kind of entertaining. But there's some big issues here and these other cases to think about, in my opinion. And I appreciate all the different perspectives on it. And that a lot of people who come to the stream are very reasonable, and they bring a lot of good things to think about. So that, I think, is going to be it. And I'll be on Eric Hundley's show at noon, as far as I know. And, we discuss things a little more loose than I do here. So if you're interested in, if I didn't make you angry enough here, you can come on that one, and there's a good chance I'll do it there. But also, he has great people on the show, which is why I don't know why he has me on it, but I love it because I get to talk to a lot of really smart people on that show. So it's a lot of fun for me. So I appreciate Eric doing that. And I will talk to you. If I see you then, great. If not, I hope you have a good weekend. I'll talk to you later. Thanks. Bye.